my name is Rachita Mathur, currently working as a legal intern at LEXCLIQ. So today I'll be dealing with the topic writ of habeas corpus. The writ of habeas corpus is a legal procedure which acts as a remedial measure for the person who is illegally detained. The term habeas corpus is the Latin word which means to bring or to present the body before the court. It is the most important right which is available to the person detained unlawfully. The basic purpose for which this writ is used is to release a person from unlawful detention or imprisonment. This writ is of great importance as it determines a person his right to freedom and personal liberty. Now, there was one example like A has been taken into a custody by B, a police officer, without a warrant. All the efforts made by A family to know the whereabouts of A turned out to be futile. As he was detained wrongfully by B, a police officer, the writ of habeas corpus can be filed in a court by A family on this behalf. Now, while looking at the nature of this writ, the concept of habeas corpus can be traced by way back in 13th century, and the writ of habeas corpus cum causa is an order calling upon the person who has detained another person to present the person in the court and justifies action that on what grounds and under what authority he has been confined that person. If the court doesn't find any legal justification for the cause, then it will order for immediate release of the person confined or imprisoned. Now, who may apply for the writ of habeas corpus? The person confined or detained illegally, the person who is aware of the benefit of the case, the person who is familiar with the fact and circumstances of the case and willingly files an application of the writ of habeas corpus under Article 32 and Article 226 of Indian Constitution. Now, the writ of habeas corpus can be refused when the court doesn't have the territorial jurisdiction over the detainer, or when the detention of a person is connected with the order of the court, or when the person detained is already set free, or when the confinement has been legitimized by the removal of the defect. The writ of habeas corpus will not be available during an emergency when the competent court dismisses the petition on the ground of merit. Now, whether the doctrine of res judicata applies to this writ. When it comes to the illegal confinement of a person, the doctrine of res judicata is not applicable under Article 32. A successive petition for writ of habeas corpus can be filed in a court with a fresh ground which were not covered earlier petition filed for the same. The petition for habeas corpus is maintainable if it is filed in a forum having its independent existence and a separate jurisdiction and competency. Now, there was one case of Lalu Bhai Jogi Bhai Patel versus Union of India and others of 1980. In this case, it was being held that no second position for the writ of habeas corpus is maintainable in the court if filed on the same ground as of the first one. Now, in case of preventive detention, the preventive detention is the confinement or the imprisonment of a person in order to prevent him from committing any kind of offense in future. It does not act as a punishment or penalty imposed upon a person. It is just a precautionary method. The concept of preventive detention and habeas corpus come in hand under Article 22 of Indian Constitution that states the procedure of preventive detention and require a strict adherence of law. The Parliament is authorized to make law for preventive detention for various reasons connected with it, like defense, foreign relation or affairs of the country, with very purpose of providing security to India and its state for maintenance of public order. However, such detention may be monitored through a judicial review by checking its precondition. Now, in case of alternative remedy, it is not refused on the ground of availability of the alternative remedy of the applicant. In case of burden of proof, it lies over the person or the authority who satisfy the court that a detention or confinement of that person was made on a legal ground. In case of territorial jurisdiction, which is provided under Article 32 of Constitution, the Supreme Court has a jurisdiction over all the authorities within and outside the territorial jurisdiction of India, which is provided under Article 226. The High Court has given power, and under Article 32, the Supreme Court has been given the power. Now, a writ of habeas corpus during in case of emergency proclamation. Now, the writ of habeas corpus is maintainable during an emergency proclamation, as after 44 amendment in 1978, it was being stated that the fundamental right enriched under Article 20 and 21 can't be suspended, and for the enforcement of these rights, the writ petition can be filed in the court. Now, there was one case of Additional District Magistrate of Jabalpur versus Shiv Kant Shukla 1976. In this case is also known as habeas corpus case, as it was based upon the ground of issuance and the visibility aspect of the writ. Now, this whole case spins around the situation when the emergency was proclaimed and the question was raised whether the writ of habeas corpus is maintainable in this situation or not. In this case, it was held as in case of Liversidage versus Anderson. During an emergency, all the rights were being held suspended. The same was held in this case also, where a state has the power to restrain the right, especially right to life, that is enriched under Article 21 of Constitution in an emergency situation. This decision was considered to be the darkest day of the Indian history. That's all for the day. Thank you.